Hi everybody, I'm Patrick Heller from the Natural Resource Governance Institute, and welcome to this Hangout session. Now in this week, week 4, as you all know, we are going through some of the issues related to the legal frameworks governing the extractive industries. Laws, contracts, regulations, as well as how the political and legal institutions in the country have an impact on the way these industries are run. We'll touch a little bit on international law as well, but really try and tie together a lot of the core legal concepts that determine how successful or unsuccessful these industries are in promoting sustainable development out of extractive industries. And to guide us will be the great questions that you all submitted as part of the course. Thank you very much to all of you who submitted the questions. I'm going to go through them one by one and do my best to try and give as complete an answer as I can. But as you know, throughout the course, if there are any follow-up questions that come through, feel free to get in touch with the organizers and we can provide more detail. So taking the first question, a question that says, are civil society organizations sufficiently endowed with capacity to pursue legal frameworks in countries that produce oil and gas, in particular in the developing world? And what are the means available to achieve this? So what I take from this question is that you're really interested in looking at how civil society organizations who are in a formal sense not part of the legislative or contracting process, how can these institutions have an impact on the outcomes of these processes? And you know, you put your finger on one of the most important elements of it, which is capacity. And there are a lot of countries where civil society organizations either don't have access to the fundamental information that they need in order to impact the legal framework, or they haven't been able to invest sufficient time in developing kind of the skills and perspective and expertise necessary to really move the needle in terms of how these frameworks are being developed. So the development of both an informational environment that enables CSOs to get the information they need, as well as a real investment in developing the skills, knowledge, and experience of these organizations is really critical, not just to CSOs having an impact, but really to the effective functioning of these legal frameworks as the sort of foundation of rules, but also the foundation of public trust. So the fundamental question, do they have sufficient capacity or can they influence the development of legal frameworks? We have a lot of examples where the answer to that question is yes, and civil society groups throughout the world have influenced these frameworks in lots of different ways. In the legislative development process, right, when the executive and parliaments are forming the fundamental rules that govern these industries, there are lots of countries where civil society groups have been really active players in that process. One, through advocacy, right, picking goals of accountability or transparency that are really critical, and really pushing with their elected leaders to ensure that these rules are included and reflected in the framework. So we have a great example from legislation that passed just this year in 2016 in Ghana, where there were early drafts of new petroleum upstream legislation that were very heavily vetted and discussed by all different kinds of actors in Ghanaian society. And one of the things that a concentrated group of Ghanaian civil society groups noticed was there weren't strong provisions in place to ensure that the contracts that govern relationships between the Ghanaian government and companies would be published, would be included in the public domain. So there was a sustained period over the course of the many months, really even years, in which this legislation was being debated by Ghanaian civil society to say, okay, if we want this legislation to really work in the best interest of our country, this transparency provision is fundamental. And there was a sustained campaign of public education and political pressure that ultimately resulted in the legislation that was passed having provisions that say, okay, contracts do need to be in the public domain. That is the norm and that is the rule that we're establishing. Beyond that kind of advocacy, civil society groups, and in particular, if you define civil society fairly broadly to include researchers, think tanks, and universities, are often really important players in informing the way that the legislative process looks at institutional design, or looks at kind of what the likely impact of a particular set of rules is going to be on how the sector is managed. So by doing independent research, by looking at the experiences of other countries, by really examining the kind of intersection between proposed rules and their likely implementation in the country, these independent actors have been incredibly useful resources for knowledge and thinking as the executive and as the legislature are defining the system. Then if we go beyond the process of legislation, or even beyond the process of making rules and regulation, civil society groups have had a really important role in the sort of last pillar of the legal framework in a lot of these countries, which is the contracts. Right now, CSOs typically are not involved in the contracting process in a direct way, but there are lots of examples of countries where concerted efforts by publicly oriented interest groups have really put pressure on governments and on companies to say, these are, the following are critical provisions that we expect as an outcome of a contracting process. So to get issues of social impact, or to get even particular fiscal issues on the agenda in a very prominent way, has been an important role that these public pressure groups have played. Now, that's not to say that they're sitting at the negotiating table or they are directly impacting the way the contracts are being executed, but by establishing a sort of political benchmark to say, okay, we need a certain standard of process, a certain standard of transparency, and these are our priorities when it comes to what is actually in the contract itself, these groups have been able to have an important impact. So I'd say that, to sort of sum up, a real strong concerted effort by civil society to impact the way these legal frameworks are structured can be really effective and is a really important component of the development of a sustainable framework. Okay, to tackle the next question on the list, is corruption and favoritism a real obstacle in oil-producing countries? Short answer, absolutely. And I'll tackle this question with a particular focus on the way that corruption and favoritism impact the development of the legal frameworks that set these fundamental rules. So, the most obvious way in which corruption can play an unfortunate role is through the contracting process. We've seen loads of examples all over the world in which contracts for oil or mineral projects are awarded not necessarily to the most capable company, but to the one that is the most connected, either via direct patronage or via more indirect networks of influence. And so what we see in too many situations is that the contract, the fundamental decision about what company will be operating in a country, what company will be given responsibility for which projects, and what the basic terms of that will look like, has very frequently been impacted by these kind of insider or corrupt relationships. That also takes place when it comes to public procurement. So not just the original award of a contract, but the processes by which subcontracts are awarded, either by a national oil company or by consortia, including both the state and private companies. And the most prominent example of this that many of you are probably familiar with is the massive Petrobras scandal in Brazil, where the state-owned oil company has been discovered, and in fact there have been dozens of prosecutions, to have colluded quite significantly with a group of Brazilian businesses to award contracts at inflated rates, with kickbacks going from the leaders of those businesses back to officials from Petrobras and to the government more broadly. What does this represent? This represents essentially a transfer of wealth, right? Petrobras is overcharging the Brazilian people, and the benefits of that overcharging are going back to individuals at massive cost to the oil sector and at massive cost to the state more broadly. Beyond sort of contracting and procurement, through lobbying and through sort of influence trading, corruption has had an all too great impact on the process of formulating legislation and regulations. Governments and legislatures that are going through this process are subject to incredibly heavy lobbying from all sides, and in too many examples, the personal interests of people who are lobbying have been put ahead of the national interest. So absolutely, I can say that, sort of unequivocally and unfortunately, corruption is a big part of the way that laws, regulations, and contracts are developed, but also the way in which they're enforced in too many countries. Okay, the next question on the list. Does the lack of a well-developed private sector impede the development of a strong national foundation for sustainable management of extractive industries? This is a great question, and I want to tackle it from a couple of different angles. So when there is not a strong domestic private sector that is capable of engaging in a competitive and efficient way in the provision of services or even the fundamental execution of projects in the oil, gas, and mining industry, it can have a really dramatic impact on the way the industry is executed, or the way that strategy is executed. Again, through a few different mechanisms. One is probably the most obvious, right? When a country has to rely overwhelmingly on international companies to execute projects and to provide the services needed for the execution of those projects, that is a share of the benefits, sometimes quite a significant share, that is not staying in the country, but is rather, the profits are being exported or transferred out of the country to beneficiaries elsewhere. Now, don't get me wrong. In many places, that kind of a relationship between a foreign company and a domestic oil or mining sector is one that is really beneficial to the national economy. These international companies can provide skills, experience, leadership that can really drive the industry forward and create a lot of benefits, both from the perspective of revenues and from the perspective of jobs and other positive spillovers. But fundamentally, money that is being transferred out of the country is money that is not staying into the country and therefore not benefiting the domestic population at quite as high a level. And so over the long term, a lot of countries aspire to developing domestic oil and mining companies that are capable of executing the projects themselves, or domestic service providers that can furnish the goods and services that are necessary for those projects to be carried out. So beyond the sort of basics in terms of benefits being exported or profits being transferred out of the country, there are some kind of legal and stability impacts of an over-reliance, or let's say a heavy reliance on foreign companies. Fundamentally, we've seen lots of places where the fact that citizens perceive all of the benefits to be shipped overseas, that can increase public dissatisfaction with these projects and can lead to protests or even to blockages of the projects, right? And so when there is not a perception that benefits are accruing in the country, it can damage the fundamental stability of these projects. And to the degree that projects are being dominated by foreign companies, it also means that the government can be subject to quite a heavy lobbying pressure of the companies that are investing, and that let's say increases or creates a certain additional type of challenge for the government in making sure that it's managing the industry in its own domestic interest. And then finally, I want to talk a little bit about the impact of the lack of a well-developed competitive private sector on domestic lobbying and the domestic political calculation in this sector. And by that I mean that when there is not a well-developed or competitive domestic private sector, that increases the chances that decisions about who to reward in the domestic economy will be based on considerations of patronage, rather than on really sound business-like economic decision-making. So I would say that to the degree that the domestic private sector in this industry is weak or is limited or is elite-dominated, then the risks of patronage-based decisions go up as compared to a situation in which there is a robust, well-qualified, rigorous private sector. Okay, next question on the list. How long are contracts between NOCs and companies operating in their state? So that varies depending on what kind of contract that we're talking about. So production sharing contracts in the oil industry, wherein, if you'll remember from the lectures, typically involve a national oil company partner working alongside or working with private companies, either foreign or domestic. That kind of production sharing contract or concession contracts, which involve NOCs as parties, or joint ventures between NOCs and other companies. Those tend to last, the fundamental contracts are typically designed for a period of 25 or 30 years, often extendable for another decade or so after that. And again, many of those agreements are structured such that there is an exploration period, which is anywhere between 3 to 7 or 10 years. And if the project proves to be successful and there's a discovery, then there's a period of, again, 20, 30 years of actual production, along with potential renewal provisions. And so when we talk about contracts between NOCs and private companies, that the sort of fundamental contract kind of structuring the rights to explore for and exploit petroleum tends to run in that neighborhood. Now, there are a whole other range of contracts that national oil companies sign. Many of them are procurement contracts whereby the NOC is looking for a particular sort of service. Those contracts in many cases are shorter, right? They are often as long as is necessary to execute the particular project. So again, there you could have something anywhere ranging from a couple of months to, if it's an important or complex contract of construction or significant investment, those can run several years as well. So quite a lot of variety when it comes to the kinds of contracts that national oil companies sign. Okay, moving down the list. Question about stabilization clauses, and I'll read it here. It says, according to the lecture, one of the dangers of individually negotiated contracts can be stabilization clauses. The justification given was that they prevent legislation passed after the signature or ratification of a contract from having effect on all or some of the terms of that contract. But here's the question: what happens if the contract violates the present laws? For example, instead of using the rate fixed by law on the royalty, the contract fixes another lower rate. Great question, and it's something that we see in a number of cases. A government has a law in the books that says here are the terms governing how oil or mineral projects are to be executed, and then we have a contract that from those terms. Now, when we're looking at the effect of that kind of a contract that goes against the law that is on the books at the time that it is signed, one thing that you have to look at is the manner in which the contract was agreed and finalized. So one reason that a lot of governments and even a number of companies like to require that oil or mineral contracts be ratified after they're signed, meaning put before the legislature and voted on, is that in one sense, ratification can be seen as allowing the parliament to have an additional kind of check on how a contract is, what has been agreed between the executive and the company in a contract. But in another sense, ratification kind of, in some legal systems, frees the hand of the government and the companies to, let's say, deviate from what is on the books in a standard way, because ratification in some legal systems is seen as essentially the passage of a legislative act, right? So you may have a mineral law that says the royalty is at 4%, and then if the government and a company agree on a contract that sets the royalty at 3%, and the legislature ratifies that agreement, in a sense, within some legal systems, that is counted as sort of a separate legislative act that then can be seen as legally superseding the pre-existing act. So to go back to what we talked about in the lecture, obviously some governments and some companies want that kind of a system because it gives them a certain level of flexibility. But what it does when you look at it in the aggregate is it means that there are all of these individual specific legal regimes that are set up, which can make enforcement more difficult. And it also creates challenges when it comes to, let's say, increasing the pressure or the significance of individual contract negotiations, where the state often finds itself under-resourced to really stand on equal negotiating footing with the companies. Now, one thing that I want to talk about is, okay, so what happens if a government has, let's say there's not a system of ratification and the government has put in place a contract that deviates from its own law. When you look at this, when you look at sort of, okay, was this is this an act that will be allowed to, an action that will be allowed to stand? One thing to look at is what I like to call the sort of interplay between the government's public law role, right, as a sovereign state that is responsible for developing and enforcing laws, and the state's role as essentially a kind of private actor in a commercial negotiation between itself, the state, and a private company. And in this sense, stabilization clauses often kind of operate hand in hand with arbitration clauses, right? And so a government will often subject itself to international arbitration, and even if it has agreed to a contract that doesn't fully match what exists within the terms of its law, to then subsequently go back on that contract and say, oh well, that wasn't within the boundaries of our law. Well, depending on the legal system, that may be within the state's sort of sovereign rights. The state does subject itself to risk of arbitration if it has agreed on something, follow the legitimate process by which an agreement is reached, and then goes back and says, okay, actually, we don't want to honor that anymore because we realized later, or we've changed our mind, and we want to stick with our law rather than what we agreed. That can get the state into significant, let's say that can pose significant legal challenges or legal consequences for the state when it comes to that contractual relationship and the enforcement of it in potential arbitration or international actions. Okay, next question. This is a question about legal scholarship, and it says, within the subject of natural resources and development, there is a huge economic and political literature, and many economic and political scholars have examined this subject with different points of views. Legal scholars, on the other hand, have paid less attention to this matter or just focus on the environmental aspects of natural resources and development. So the question is, which aspects of natural resource management and natural resources and development have been or can be the subject of legal research? So I love questions that relate to legal scholarship and how it can be as relevant as possible to real questions or real challenges that are going on the ground. Kind of a few different angles of focus that I think exist within the legal scholarship, but where there are certainly gaps worth further exploration. So if whoever asked the question is interested in pursuing them forward, further, I think there are plenty of opportunities. But to kind of lay out some of the angles of legal scholarship on this, there's a set of studies or a set of literature that has really kind of looked at targeted and pragmatic analysis of kind of individual provisions within contracts or within legislation, right? So, there's a scholarship, for example, that says, okay, there are different ways to pick up from the last question, there are different ways to structure a stabilization clause. What are the impacts legally and what have been the impacts in practice of these different manners of developing stabilization? Similarly, to take another example, let's say guarantee provisions, right? So within a lot of extractive industry legal systems, there are different kinds of requirements that are put in place that says, let's say, okay, a company that wants to act within the sector or wants to have access to a project has to put up a guarantee that says, financial guarantee that such that if it doesn't complete the work that is expected of it, it has to pay a penalty, or in some cases, it has to put money into escrow at the outset so that that money is automatically taken in the event that the company doesn't live up to its obligation. So, there's legal scholarship on, kind of how do different kinds of guarantee mechanisms work, and what are the impact of it. So there's a couple of examples, but just of legal scholarship that looks at very specific contractual or legislative provisions and says, okay, what is the impact of this, and what have they meant? So I would call that the sort of very narrow contractual, or let's say project-based analysis. At a broader level, there's been a lot of work done around how legal and governmental institutions have been structured, the kinds of checks and balances that have been put in place, and what impact those different kinds of rules, those different kinds of structures within the government have had on how well the extractive industry has been managed. So some of these look at the fundamental constitutional level, right? What is the connection between the basic institutions of government, or the basic rules on citizen, civil and economic rights, and what has that meant in terms of how well the state has been able to manage its extractive industries in the public interest. Some look, much more at, okay, what are the particular kinds of specific institutional structures that have been created, right? So there's been a lot of research, for example, around regulatory bodies in the oil and gas sector, and whether an independent regulator is more effective than a regulatory body that's based within the ministry or within the national oil company. So again, that category I would call sort of research and analysis on institutional structures and checks and balances. There's been, and there is, I think, a growing literature on kind of the process by which natural resource contracts are negotiated. That is legal in nature, because it looks at the way that deals have been carried out, and the connections between laws and contracts, and the roles that government lawyers and outside lawyers have played. But that connects to a sort of broader business, case study oriented literature on, okay, what decisions have led to what kinds of outcomes. Couple last ones that I've been thinking of. There's I think a growing attention in legal scholarship around the extractive industries on the design and enforcement of rules that govern the relationships between extractive projects and citizens, right? So there's a lot of focus lately on free, prior, and informed consent, and what it means to actually execute a practical, pragmatic, legally binding system that requires a process of FDIC in order for a project to be executed, right? Or rules on different mechanisms for determining what represents just compensation in the case of displacement for a project. And so that's again a sort of growing area of scholarship is what rules tend to work best. How do we take kind of core concepts of individual rights and rights to land and render those practical in a real world setting? And then finally, there fortunately or likely unfortunately, there's a history of disputes between governments and private companies around oil, gas, and mining projects, and there's a literature that is growing around the results of arbitration, or let's say legal analysis of the claims of different parties who are somewhere in a dispute process. Moving down the list, just a few more questions left. So the question on what the impact of the recent International Criminal Court decision to include environmental destruction cases in its assessment of crimes against humanity will have on the evolution of public law in this field. For those of you who don't know, in September of this year, September of 2016, the ICC released a policy document that, among other things, and I'm going to read the passage for you, indicated that the ICC, quote, will give particular consideration to prosecuting Rome Statute crimes that are committed by means of or that result in, inter alia, the destruction of the environment, the illegal exploitation of natural resources, or the illegal dispossession of land. Now, I'm not a very close ICC watcher, so take my reaction to it with a grain of salt, but I think this can be, this decision or this policy can have potentially a really significant impact on prosecutions potentially, although it's a little bit unclear, how aggressively the ICC will be in actually pursuing violations of these rules or of kind of environmental crimes. But beyond that, I think this can be a really important bellwether in the evolving international norms that I hope will have impact both at an international law level, but also when it comes to rigorous legal enforcement within natural resource rich countries, right? So the idea here is that in an unfortunate number of cases, the extractive industries or other big business projects have been associated with land grabs or dispossession that have a massive impact on sometimes tens of thousands or even hundreds of thousands of people. And in many cases, those are done, including in cases where there is, let's say, a government involvement in them, in violation of domestic laws and in violation of kind of fundamental international laws on the rights of individuals and on sort of the global environment. And so to have the ICC take a very public position that says, okay, we will think of these as crimes against humanity, I hope will buoy the efforts of domestic enforcement agencies as well as international actors, but that it can be a part of what will be a something that I think will take time, but what I hope will be a long-term evolution in the way that public international law views these kinds of environmental violations. Okay, a couple more questions. What should be the proper mechanism of enforcing the law, whatever it may be, in rentier states, without discouraging foreign direct investment by these countries' most important investors, which in many cases are multinational enterprises? So I think as a starting point, one thing to say is I think there is no substitute for consistency in enforcement of the law. I think responsible multinational enterprises understand that they have a set of rules that they have to follow in countries where they're operating, and put in place structures and systems to enable them to follow the rules. Where I think a lot of problems arise is in cases where the law is either inconsistent in its design or in its enforcement, right? And so where there's a government that businesses perceive to be changing the rules from one day to the next, or where it's seen that, let's say, political connections are more important than sort of a fundamental adherence to the rules of the game. And so I think the overwhelmingly most important thing is, the government should be setting tough rules, or let's say rules that protect its national interests, communicating those rules very clearly at the moment that a project is getting underway, or at the moment in which a company is applying to participate in a project, and then enforcing those rules, investing in enforcement mechanisms, making sure that the government has sufficient administrative resources to be regularly following up on what the company is doing, having agents in the field who are able to track what's happening at a project site level, and communicating on the level of compliance with the company, and identifying problems early on. When a government can do that consistently, its companies, or at least the companies that the government wants to be doing business with, can plan their activities effectively, can invest as they need to invest in compliance, and can continue to execute their activities. So I don't think that there's a fundamental problem with rigorous enforcement, and of course I think the government should be enforcing their rules as rigorously as possible. I think the most important thing for them to do is to be consistent and to communicate clearly and openly with their private sector partners and with their citizen constituents, which brings us to our next question. How does a country build trust in the legal system regarding the fossil fuel industries when it's easier, and in some cases the common practice, to elude the law's enforceability? And the questioner said, I start with the question of trust because I think it's the first step to later commence and demand transparency, accountability, and further better practices in the extractive industries. So my answer to the last question, I tried to touch on of trust between the government and companies, and clear communication between government and companies. To some extent, this is sort of the flip side of that, and it's a question of trust and communication between the government and citizens. I think the most important starting point for building that kind of trust is for the government to state in a clear and comprehensive way what are its goals for the extractive sector, right? There's legislation that's on the books, either legislation that exists or when new legislation is being imposed, that puts in place a set of rules. What's often lacking is a real clear statement of vision on the part of the government, right? To say, this is what we are hoping to get out of the oil, gas, or mining sector. And these are the ways that we have structured our rules and our institutions so as to pursue those goals effectively, right? And by saying, here's what we want to do, here's what we think we can accomplish, here's what we don't expect to accomplish, the BAT can do a strong service in managing public expectations and giving citizens a strong basis upon which to assess the government's performance. So setting those goals at the outset, I think, is critical. And then having done that, I think, again, I mean, it's to some extent the flip side of or mirrors, the communications with companies, sort of consistently coming back to citizens and saying, how are we doing, right? These projects that we thought would get underway, how well are they doing compared to what we expected, right? The rules that we put in place, how well are we as a government and how well are our private sector partners living up to those rules and enforcing them? And creating strong systems or strong mechanisms by which citizens can provide feedback, ask questions, and raise concerns. We in NRGI actually, hopefully before the end of this year, will be coming out with a publication on the positive steps that a lot of governments in the oil and gas industry have taken to communicate on enforcement of their legislative, regulatory, and contractual systems. And what we've seen is that in the countries that are doing it best, there is a regularly updated set of government communications that includes the raw data, but also invests some real attention in joining up the different data points and in explaining to different kinds of constituencies, okay, what does this mean, right? We are earning this much revenue. What does it mean in terms of our public budget? Or what does it mean in terms of how much we expected to earn, right? We've taken the following steps to deal with environmental risks and to mitigate them. We've had these incidents, these problems. What have they meant? What have the costs been? And how have citizens who've been negatively impacted by them been able to get their grievances addressed? And so, the systems that seem to work the best in terms of generating public trust are systems that are very consistent and that aspire both to, or simultaneously to, present raw data, explain that data, and create a two-way street for communication between the people and the state. Let's see if I have any more. Okay, last question is on corporate social responsibility. And so the question is, please describe a framework to solve corporate responsibility projects, without compromising an IOC, So I think what the question's getting at is, well, again, looking at it from the perspective of the legal framework, which is the subject of this week's sessions, what I take the question to mean is, okay, so what are systems that can be put in place to harness efforts for what are often framed as corporate social responsibility to have a positive impact and to avoid certain challenges? And I want to divide my answer into kind of legal mechanisms and then a sort of broader set of strategic mechanisms, including many things that the private sector has been leading the way on. From a legal perspective, I think there are several things that a state can do to, let's say, structure the contributions that that companies are trying to make to communities, and to avoid some of the challenges, including some of the mistrust that often arises out of those projects. And here's a few of them. So some governments have legislated a sort of minimum contribution that oil, gas, or mineral companies have to make at a community level, right? So it says, the company, often it will be based on a sort of, either turnover or, kind of gross revenue that says, X% of gross revenue shall be paid to either the local government or to some kind of body that is created to develop projects at a community level. Now, the simple requirement of making that kind of payment doesn't in itself solve any of these problems, right? Local government corruption exists just like it does at a national level. And so the systems that have been most effective not only require a contribution, but create some rules around how that contribution is going to be managed. So transparency around payments, some kind of structure by which projects that are developed around or using these contributions are to be managed, guidance against, let's say, self-dealing on the part of local government, the local decision-making bodies, etc. Other governments have tried to standardize to some degree the kinds of community development agreements that are signed between extractive companies and their communities. So by providing a sort of model community development agreement, the idea is that the country can, let's say, put different communities on equal footing, help communities benefit from kind of expertise that's been gathered across the country and even internationally, and avoid the community, let's say, committing to things that months or years down the road, community leaders or citizens may determine are not sort of maximally in their interests. There's a useful, if for any of you that are interested, the World Bank several years ago came out with a very useful publication on designing and structuring community development agreements that also includes a sort of model regulation that governments could adapt in order to try and structure these kinds of relationships. So those are a couple of legal mechanisms. Slightly more broadly, companies have done a lot of thinking on how to manage their relationships with communities more effectively. And that's not to say that all companies have done it well, but the private sector, in particular, with a lot of the problems that mining companies have experienced, mining companies and groups like ICMM, the International Council on Minerals and Metals, have tried to sort of examine, okay, what are the key components to making community development agreements or making corporate social responsibility agreements effective, both in terms of their fundamental goal, which is supporting development in the community, and in terms of helping make these projects more stable. And a consistent thread that runs through a lot of these recommendations is communication at the outset, right? It's finding and identifying who are the members of the community that it's most important to be involved in these decision-making processes, having collaborative discussions on what the community's priorities are, and reaching decisions together, after significant consultation on what kinds of investments are in the community's best interest, and importantly, how responsibility will be shared for executing those commitments, not just at the moment of signature, but over a period of time. So, I think regular, consistent communication and a real attention to transparency of results, right? So that all in the community can be aware of what has actually been delivered according to what kinds of agreements and what has been the impact of it is the key to sustainability. One thing I'd note is that the Sustainable Development Goals, I think, can provide a useful sort of hook upon which, let's say, goals of what is most important or what is most needed in a community can be set, right? It can help businesses and local leaders and national leaders sort of say, okay, how do we structure our priorities and how do we design them over a period of time in a sustainable way? So with that, I'd like to thank everybody who submitted questions, and looking forward to continue to hear your feedback on the course as it goes forward. Take care.